Welcome back to All Bright Minds to our SQE 1 Chapter 4 of Contract Law session. So by now we know that offer, acceptance and consideration form the backbone of contract law. So we will try to look at the heartbeat of contract, and that is intention. So we'll try to look at, did the parties actually mean for their agreement to be legally binding, not just friendly promise, but see you in court if you break it serious, So we need to look at, if someone says, see you tonight at Turnpike Lane pub at 6 o'clock, So at that point, do you think if they don't turn up and you get emotionally broken at that point, can you call them to court? So the law uses an objective test, not what parties secretly thought, but what a reasonable person would think from their words and conduct. In other words, it does not matter if you quietly muttered, "I was only joking." If you looked serious, the law might take you at your word. So your state of mind is irrelevant. Your behavior is everything. Lawyers call this objectivity. Your parents might call it taking responsibility. So yeah, so those are all not only words, those are promises, sometimes kept in law. If you are serious and an objective and reasonable person thinks that you made them. So to make life easier, or perhaps to make exam trickier, the law starts with two presumptions. First, societal, social, and domestic agreement are presumed not to create legal relations. Inviting someone to pub and not turning up is domestic agreement. Social arrangements, promises with families or friends are generally seen as moral, not contractual. Second is commercial. Presumption of commercial agreement to create legal relation because it is business. And people rarely promise things out of love and kindness in commercial relations. These are starting points, not a final answer. Either presumption can be rebutted with evidence. And this is where the fun begins, when dinner table promises turn into courtroom dramas. Sometime it happens. And we'll see that how those intentions are rebutted. So for example, let's start at home, where promises are often generous but rarely enforceable. I'll make you a cup of tea in the evening. If I say to my partner at that point, do you think it is a contractual promise? So the classic case in front of us is Balfour versus Balfour from 1919. Mr. Balfour promised his wife £30 a month while working abroad. When the marriage broke, she sued for the money. The court said no contract existed. This was a domestic arrangement, not a business deal. The judge basically said courts are not marriage counselors, because it was within the marriage, like they were husband and wife, and the promise was only domestic arrangement. Now, there is contrasting judgment in merit versus merit, and that's what people struggle with. They think it's a bit same, and why the courts have gone otherwise, I will try to explain it. The couple had separated. Now there they were married, and here they had separated, and the husband signed a written agreement promising his wife the house if he paid the mortgage. The court said this was legally binding because things were wrong, and there it was love and affection and husband and wife relationship. The love had gone and only formality remained. The rule of thumb: happy home, no intention; broken home, full intention. So the next thing is, Social promises between family members or friends also tend to fall outside legal intention. In Jones versus Bedouin, a mother promised her daughter a house and maintenance if she studied law. Wow, no one promised me this. The daughter did, but the relationship soured, as they often do when law student and rent collide. So the court held it was a family arrangement, not a contract. However, the presumption can be overturned if the agreement is written, formal, or involves reliance and expenses. Court may find legal intention. For example, a brother and sister jointly buying property or signing an agreement with witness would likely be seen as serious, not a domestic agreement. So when analyzing an exam question, always ask, are we talking about Sunday lunch or a solicitor's office? Context tells you everything, so don't get confused. The next thing is commercial agreement. Now, we step into business world where smiles cost extra and promises usually come with invoices. In commercial agreement, the presumption flips. Parties are taking something serious and they intend legal relations. The reasoning is simple. No one signs a contract over coffee for the fun of it. Like, for example, in Edward versus Skies, an airline promised an ex gratia payment to redundant pilots. The company later tried to wiggle out, claiming ex gratia meant goodwill only. It was not like something we intended at that point. The court disagreed because it was a business. Even kindness comes with legal strings. In Esso Petroleum versus Custom, Esso gave away World Cup coins with petrol. The court held that promotion involved intention to create legal relation. The coins might have been free, but the legal responsibility was not. In short, if money or business advantage change hands, intention almost always follows. How to rebut it? It can go other way as well, as we did with the domestic relationship. Of course, like business people sometimes want to keep things informal. Simply, the lawyers are hovering nearby with expensive pens. In Rose and Frank case, the parties included an honorable pledge clause stating their agreement was not a formal or legal agreement but only a declaration of interest. The court respected this, holding it was not legally binding. So commercial intention can be rebutted only with crystal clear wording. Phrases like binding in honor only or subject to contract show that the parties did not want legal consequences. The court will not second guess that decision. So if you ever see subject to contract, think of it as the legal equivalent of we are not official yet. It will be official in the future, but this one is not. Subject to contract and preliminary agreement. Subject to contract is one of the most powerful phrases in English law. You will see on property market that this house is sold subject to contract. It signals that the parties are negotiating, not committed. In confetti records, negotiations were marked subject to contract. The court held that no binding agreement existed until the formal contract was signed between parties. This is especially common in property transaction, I have already said. So, where the last thing you want is to be accidentally married to a house. So, remember, subject to contract mean talks are ongoing, no contract formed. Once the final deal is signed, only then does the legal magic begins, not before that. So, the next thing is collective agreement. Not all professional agreements have legal bite. In employment law, collective agreement between trade unions and employers are presumed not legally binding. unless they explicitly say so. This is confirmed by Section 179 of the Trade Union and Labour Relationship Act 1992. That's why sometimes they say everything is agreed and the next day they go on strike. Similarly, agreement involving government bodies often requires statutory procedure or formal approval before becoming binding. Without those formalities, they remain political promises, not legal ones. So in the SQE, if you see a collective or government contracts, always check for statutory wording or express intention. Otherwise, those are not contracts. So to our favorite tips and common pitfalls. So some tips we will try to focus, and then we will discuss some common pitfalls as well. So tip number 1 is always identify the context, social or commercial, and state the starting presumption. It remains same unless and until it is rebutted. Always the objective test. What would a reasonable observer think about the party's intention? Tip 3, drop the key cases. Try to just understand them. Try to just have a good grasp of them. So, another thing, look for wording like subject to contract, binding in honor. They almost always defeat intention. So, then try to just look at how presumption that was normal can be rebutted. And common pitfalls are assuming all family agreements are not binding. Not at all. They can be binding when relationship break down. Forgetting that commercial parties can opt out of intention if the wording is explicit. Yes, they can opt out. Mixing up intention with consideration. Those are two very different concepts. Ignoring statutory presumption like 179 we have talked about, any trade union kind of things, those are not binding. Remember, in every SQE1 question, you are the reasonable person, so act reasonably. Ask yourself, would you think this agreement was meant to be legally binding? If yes, say so and explain why it is. So wish you all the best with this topic, and I'll see you with the next topic, that is consideration. So ta-da.